back for our Law and You segment sponsored by Gig and Jancola. We've got attorneys Christopher Jancola and Michael Gig. What do you know?
There you go.
From the practice, right here in the flesh. Good morning, you guys. Chris, break it down, the types of law that you guys practice over at Gig and Jancola.
Well, I do personal injury, workers' compensation, Social Security, disability. Mike, of course, does our wills, trusts, estates, and real estate, and probate, right?
I guess, but what the heck does that mean?
Yeah, so that's the question we were going to go over.
You said a lot of people don't really understand.
Yeah, it's a term that's thrown out a lot, but I don't think people really exactly know what it means, or at least just clients that come in. So probate, there could be, I guess, several definitions, I guess, but the basic definition is it's actually having to open an estate, go to the courthouse, and officially open an estate at the Register of Wills office. Like in Blair County here, go to the Blair County Courthouse, go to the Register of Wills. If there's a will, you bring the original will with you, you bring a death certificate, and then you have to present a petition that the executor or the administrator would have to sign in front of the Register of Wills to officially open the estate. So probate basically is, there are certain assets that the person, when they died, the only way to get those assets to their beneficiaries or their heirs is that you have to officially open an estate like that at the courthouse. So we distinguish between probate and non-probate assets. That's one of the first things I explain to people is there are non-probate assets, meaning you don't have to open an estate in order for those assets to get to the beneficiaries or your heirs. Those would be any assets that are jointly owned, okay? So if a person that died owns something jointly, whether it's with a spouse, with a child, that could be joint bank accounts, that could be, they're on a deed to real estate jointly. We talked about real estate, there could be caveats there, but it would go to that owner. So you would not have to open an estate for it to get to the other person. It automatically goes to the surviving joint owner. The other one is things like life insurance, IRAs, 401ks, annuities. Those have beneficiaries you can name, okay? So whoever those beneficiaries are, they can claim that account after you pass, provide a death certificate, fill out a claim form. Don't need an estate in order to open those up, okay? The only way you would for those accounts is you didn't name a beneficiary, or you named someone, that person died before you and you didn't name a backup. So the default is it goes to the person's estate. So probate is basically saying, hey, there were assets in this person's name, they were in their name alone when they died, and there was no beneficiary set up that they could claim it that way. And so the only way to get that asset into their names is to open an estate.
Okay.
That's the most basic way to say it. And a lot of people get worried about probate. It's such a, you know, kind of almost derogatory term at this point. Well, we want to avoid probate. Well, there are ways to do it, but just because you have to go to probate doesn't mean it's a difficult thing, at least in Pennsylvania and specifically in our surrounding counties here. It's a pretty simple process. It's not extremely expensive unless it's a very large estate.
Yeah.
And I tell people, you know, when you go to the Register of Wills, that process can take a half hour or less to get the estate open. So it's not the most daunting thing in the world to actually do that.
Okay. Well, one of those things too, I'm sure you hear a lot of terms that get tossed around and kind of used out of context, right? Yeah,
I mean, probate's used for in the most general sense, but legally it's that term that actually opening up an estate, it's on public record at that point. But it's not the most daunting thing in the world, especially around here. That's why I try to tell people it's not a complicated process to get the estate open. Now, once it's open, there can be some difficult things, but the process of just opening the estate is not that difficult.
Do you need an attorney to go that route, or can you do that sort of?
I tell people, of course, I would tell people you should, or at least get counsel from an attorney. What I often find is people can maybe get the initial process of getting the estate open because maybe that's not too difficult, but then they might come back later on because things happen. They're not sure what to do. Filing an inheritance tax return, you know, that can be sometimes difficult. they'll come back and say, hey, can you finish this for us? So that's why I say actually opening the estate is not that difficult. But from there on, I would suggest, yes, an attorney.
Yeah, get an advocate from the get-go.
Yes.
Kind of on a lot of these matters we talk about. If people want to reach out to you guys, what's the best way to do that?
Yes, please give us a call at 814-946-1606 or go to gig-law.com.